Yes.
This your ladyship. I'd like to mention hearing item number 7.
Item 7. Yes.
Hearing item 7. May it come up after 2 weeks.
2 weeks. Why?
I was asked to produce some documents relating to the contract issued to the petitioner.
2 weeks. Learned Senior Government Advocate Mr. Mohamchan prays for the listing the matter after 2 weeks in order to receive certain instructions. So, praise the Lord, Learned Counsel for the petitioner, Mr. W. Mar, who is present. List after 2 weeks.
Oblige.
Please, Lordship. Lordship, I beg to mention hearing item number 7. Lordship, if this matter can come up after.
7 is just mentioned. 7.
My apologies. Item 6.
Item 6. Yes,
Since my senior is out of station, if this matter can come up after a week.
after a week. This seems to be a very old matter, no?
Yes.
Yes, my lord, I'm appearing for on behalf of additional AG, we separate.
Who? Visukre.
We separate, yes.
Learned counsel for the petitioner, Mr. Such and Such, makes a mention on behalf of the leading counsel, MS Naksantila, to release the matter after 1 week, as the leading counsel is out of station. So, the learned government advocate Hipapong is present on behalf of Ms. Vishukri. Please admit Mr. matter after 1 week.
Much obliged.
Much obliged.
Please, my lady. Then, I beg to mention admission item number 1, my lady. My lady, due to other professional engagement, I will not be present before this honorable court today physically. With your consent, can it be listed on 11th of August, my lady? I have also the consent of the other side.
So these are connected, 1, 2,
Yes.
and 1, 2, and 3.
Yes, connected, my lady.
1 and 2. 1 and 2.
Oh, 1 and 2, yes. 1 and 2. I heard learned counsel for the appellant, Mr. V. Devnath. who
Lordship,
plays
may this be fixed on the 18th?
18th.
We can
18th
Okay.
has made a prayer for listing the matter on 18th of August. So, learned counsel for the respondent, Mr. Imti Wapang, is present and has no objections. List on 18th August. Yes.
oblige.
May I please, Your Lordship? I beg to mention hearing item number 8. My senior is out of station. So kindly let the matter be refixed next Thursday, that is 7 August.
7th August. Learned counsel for the petitioner, Ms. Such and Such, makes a mention on behalf of the leading counsel, Mr. Sentianger, who has some difficulties today, and prays for listing the matter on 7th August. Learned government advocate, Mr. K. Angani, is present and there's no. Yes, Paul?
For more item number 9 from the supplementary course list.
May I please, Your Lady?
Yes.
I filed this petition under 538 for quashing of an FIR, which is in page number 16.
Your course title, it should be 528, no? Not 582.
Oh, yes, my
It
Honor.
is 482 CRPC, but BNSS is 528.
Okay, Your Honor. Please allow me to give me the liberty to
Just-
change.
just, yeah. Put your signature and change it.
Okay, thank you, Your Honor. Thank you so much.
Yes.
Your Honor, the FIR is page number 16. It has been written by this Konyak Students Union President and Secretary, FIR.
Yes.
Regarding allegation of abuse of a child of the community by the petitioner here. Then thereafter, he was arrested and then he was released on bail. Then subsequently, on the date of 24/7/2025, the Konyak Union and Kohima Our Tolongjin, they had a meeting, and the compromise has been entered between the two communities, the Konyak and the Our Union Kohima. And subsequently, a date of compromise has entered, which is annexed as page number 24, Your Honor.
24.
Annexed T.
Yes.
This is a deed of compromise, Your Honor. And page number 25. And page number 25 is the page where the parties to the complainant, the victim, and the accused parties have signed, and the deed of compromise. Thereafter, Your Honor, in page number 26, the complainant party, that is the Konyak Students Union, they have also written a letter to the officer in charge, the women police station, praying for withdrawal of the FIR that they filed on 14/5/2025.
Okay. Who's appearing? But is this a joint petition
No,
or?
Your Honor, give me the liberty to keep them on the register as well as trustees on the trustee service.
My lord, I may bring for respond number 1.
This present petition under section 528 BNSS has been filed by the petitioner praying for quashing of the FIR
Yes, Your Honor.
lodged in Kohima Women PS case number 0005/2025 under section 115 clause 2 BNS read with section 75 of the Juvenile Justice Act. Stop. Para. Learned counsel for the petitioner, Mr. Alamuabang, submits that the present case was that the case was registered on receiving the FIR from the from what?
Konyak Students-
from the
Students Union.
Konyak Students Union on which date?
14/5.
14/5/2025. So, and accordingly, the Kohima Women PS case number 0005/2025 was registered. So it is further stated that the accused and the complainants have already entered into a compromise compromise deed dated 24th July 2025. And accordingly, prays that the GR number, that the connected GR number, no, corresponding, that the corresponding GR number 46/2025 in connection with Kohima Women PS case 0005/2025 and the FIR may be quashed and set aside. Stop. Issue notice.
Your Honor, I will pray if the investigation may be stopped in the interim. The investigation pending.
Right, right. Issue notice to the respondents number 2, 3, and 4, returnable within 4 weeks. Stop. Learned PP appears for the respondent number 1, State of Nagaland, and hence no formal notice is called for. Stop. The petitioner shall take steps for service on the respondents 2, 3, and 4 by registered post as well as by dusty mode, and thereafter file an affidavit to that effect. Stop. List after 4 weeks. In the interim, it is directed that the investigation in the GR case
46.
number 46 of
2025
shall remain suspended till the next returnable date.
My lord, a scan copy of CD may be obtained. Allow me to obtain this.
Yes. On the next date, the learned PP shall obtain a scanned copy of the case diary.
Thank you, Your Lordship.
Much obliged.
For motion, item number 10.
May it please your lordship.
Yes.
I beg your apology. In this matter, the leading counsel, Sir Mohammed Shaminuddin, is an outstation advocate. Since she could not be able to turn up today, kindly list the matter after 1 week.
After 1 week.
Yes, your lordship. And your lordship, my senior name, Mohammed Shaminuddin, may be kindly reflected in the cost list.
Learned counsel for the petitioner, Mr. Sergeant Sir, your name, has submitted that, give your name to the,
Jendemo.
has submitted that the leading counsel, Mr. Shamimuddin, is an outstation lawyer and accordingly could not be present before this court today due to some difficulties. So he has prayed for listing the matter after 1 week. Do you want a fixed date?
If it please you, your lordship, kindly fix on 7th.
7th. after 1 week. Stop. Accordingly, this is the matter on 7th August 2025 for motion.
For motion, item number 11.
Oh, and then the name of Mr. Shaminuddin. The registry is directed to reflect the name of Mr. Shaminuddin as counsel for the petition in the cost list.
Your Lordship,
Yes.
item number 11 and 12, similar
Similar
prayer.
prayer. Okay, 11 and 12 also same. And then you write that, no? Registry to reflect the name, okay?
Much obliged.
Yes.
For motion, item number 13.
May I please, Your Lordship?
Where's the other side? Actually, that amendment.
Yes, Lordship, I'm praying for amendment.
Again, you have made a mistake. See your paras 5. You have not, you're supposed to state, you know, this from this, and this, what those entire sentence which you want to incorporate.
Lordship, in my
You have to
paragraph
reflect it in your,
Yes.
petition.
To make necessary
But you have
amendment.
not put anything.
Lordship, in paragraph 5, I've already stated that
No,
to make
see,
necessary.
you have only stated to incorporate the administrative approval such and such and to make necessary amendment in the writ petition and in the prayer portion. That's all.
In para 9 of the writ petition, in the prayer portion as well as in para 9.
Yes, I understand that's where you want to make the amendment.
Yes.
But what you want to put in, the specific sentence, the entire sentence you have to reflect in your petition.
Lordship can.
See,
Yes.
if you have never filed an application for amendment, you should ask someone who has done it before. This is not the way to do it.
Lordship, then I may be allowed
Again,
to
it is
withdraw-
incomplete.
Yes.
You ask someone, you withdraw this.
Yes, Lordship. Much
Learned counsel for the applicant, Mr. Temchin, please for withdrawal of the IA with liberty to file a fresh. Prayer is allowed. Petition is disposed.
Lordship, in the meantime, interim may be continued
The
in the main
interim
petition.
order passed in the in WPC 269 of 2023 shall continue till the next day.
Much obliged.
For admission, item number 3.
May I please, Your Lordship?
Yes.
Actually, I made a mention in court number 1 for moving one unlisted urgent matter. But then my Lord has expressed some difficulties and requested herself to make a mention here.
Oh.
So I am mentioning that I may be allowed to move one urgent unlisted motion.
Okay, bail or what?
No, this is with regard to the admission in medical colleges selection in the medical MBBS seats, Lordship.
Okay.
And the petition is in the process. So let it be a conditional one.
Let it be
And then
called as
if
and
it
when
is
it is ready.
as and when it is ready,
Yes.
or otherwise at 2,
Okay, okay.
whichever is earlier, Lordship.
Okay. Whenever it reaches. No? Yes. Yes, what is this?
Please, Your Lordship. The IA 45. At the time of filing the appeal, we did not have sufficient stamp. That's the reason why we filed this application under Section 149 of the CPC. My Lord, the...
IA 45.
Yes, Your Lordship. My Lady, we have already filed the necessary requisite stamp duties before this Honorable Court, so this IA may be disposed.
You have already filed.
We have filed.
Filed stamps. Okay.
Sufficient stamp duty, yes.
IA 45. This application under Section 149 of the CPC has been filed, praying for leave of this court to file the connected appeal FA2 of 2025 against the judgment dated 27/11/2024 and decree dated 28/11/2024 passed by the Court of the Civil Judge Senior Division Kohima with deficit court fees. Stop. Learned counsel for the petitioner, Mr. Joshua Sheki, submits that in the meantime, the requisite court fee stamps have already been deposited with the registry of this court, and therefore submits that the petition may be disposed of. Stop. In view of the fact that the deficit court fees have already been deposited in the court, this application is disposed of infructuous. Now that you have deposited, is disposed of as infructuous.
My lord, by the earlier order of the Zombie Court, in the main case, the lower court record
It's
was
here.
called for.
Yes.
So if it is come, then, my lord, an order may be...
Hearing.
No, your lordship, for preparing the paper book. If a direction may be issued for preparation of the paper book.
In FA2. Learned counsel for the petitioner and the respondents number 1 and 2. You are for 1 and 2.
I'm appearing for all the respondent.
Learned counsel for the petitioner, Mr. Joshua Sheki and Mr. M.T. Chang
Yes, Lordship.
are present. So the trial court records have been received. Stop. Noting list the matter for hearing after. No. Accordingly, the director's registry is directed to prepare the paper book,
My lord.
and thereafter list the matter for hearing.
Lordship. Lordship.
For orders, item number 4. I beg your pardon, for admission, item number 4.
May I please, Lordship?
Yes.
My lord, I have received the status report.
Oh, Judge, this is that anticipatory bail.
Yes, my lord. The accused was appeared on 29/7/2025, and his statement was recorded, my lord. May I read, my lord?
Yes.
I have the honor to report that on 28/7/2025, Sri so-and-so appeared before the investigation agency at 2000 hours. However, he was directed to appear before the investigation agency on 29/7/2025 at 11:30 hours. Accordingly, Sri so-and-so appeared before the investigation agency, and during which his statement was recorded. On examination, he stated that he is a businessman and has been running a temper shop for the past 15 years. He knows Pratip Singh since 2020. He had business transaction and relation with him till the 2023. He had cleared all the pending payments to Pratip Singh. Since 2024, Pratip Singh has not been in contact with him. Accused Pratip Singh has wrongly and falsely stated in his statement that he has to make him some payments, and as such, Pratip Singh could not clear the bills of the complainant. He further stated that he has cleared all the payments pending with Pratip Singh only. The complainant is unknown to him and he had no dealings with him. It is regretfully to inform your honorable court that Sri so-and-so did not bring any CGST bills, cash transaction records maintained at his shop, which he was directed to bring at the time of his appearance before the examination. Further, the accused denied taking the consignment in the year 2024. However, the complainant has provided all the GST bills and e-way bills. The drivers of the said truck has also stated that he has delivered the said consignment along with the GST and e-way bill, and it was handed over to so-and-so. Hence, so-and-so was again directed to appear before the investigation agency with the GST bills and other relevant documents to prove his statement. So, my lord, 1 week time was given to the accused to appear, to reappear. So, my lord, my humble submission is let the accused produce all these GST and the e-way bill. So, the matter may be heard after a week, my lord.
Yes, petitioner is here.
Yes, she was here.
Am I audible?
Yes, yes. Learned counsel,
Yes.
the statement of the petitioner was recorded. However, he could not produce certain documents.
But your ladyship, since he is, if I may please, since he's complying with the court order, he's complying with the investigation, with the police. In that case, it's just a short prayer for an absolute anticipatory bail. I would request that be granted.
No, we will extend the interim, and then you produce all the documents. After
Yes.
that, we'll make
Yes,
it.
ma'am.
If I may please, your ladyship, the main accused is out on bail. The person he has mentioned, if I may take your attention to Annexure
Pradeep
B,
Singh.
Pradeep Singh is out on bail. And if I may take your attention, your ladyship, to the Annexure B, page 18.
B.
Yes, page 18.
Yes.
The main accused had mentioned two people here, Uday Deka and Guneshwar Bharali. If I may please, your ladyship, Guneshwar Bharali has been granted an anticipatory bail on the 10th of this month by this very honorable court in the vacation bench. The same charges, your ladyship.
Okay. Guneshwar Barali.
Yes, his case number was AB 1565 of 2025, your ladyship.
Yes, PP. If that's the case, then
No, my lord, since the
because
accused has
similar
not.
similar charges.
Yes, my lord. So, my lord, let him first produce these documents. After that, the matter can be heard. my lord.
And if your ladyship, he'll continue providing the documents. He's not evading the police investigation. He's complying with it.
This is appearing before the IO also. I think it
Yes,
should be
yes.
a problem.
Yeah, and he's within the
When was
jurisdiction
the
of this
interim
honorable.
granted? 26/6.
Yes, my lord, 26/6.
Yes. Learned counsel for the petitioner, MS Shanil Kalita, and also learned PP Mr. Thibapong for the state respondents. Stop. The learned PP has produced the latest status report received from the investigating officer, dated 29/7/2025. Stop. According to the status report, the petitioner had appeared before the investigating agency on 29/7/2025, and his statement was recorded. Stop. During the recording of statement, it was observed that the petitioner did not bring any of the CGST bills or the cash transaction records maintained at his shop, which he was directed to bring at the time of his appearance. Stop. He was directed to bring these. Why didn't he bring them? Stop. Further, the accused had denied taking the consignment in the year 2024. However, the complainant had provided all the GST bills and the e-way bills. Stop. Therefore, on 29/7/2025, the petitioner was again directed to appear before the investigating agency with the GST bills and other relevant documents to prove his statement. Stop. Learned counsel for the petitioner submits that the main accused in the present petition, that is one Pradeep Singh. Pradeep Singh already granted bail. Pradeep
Yes,
Singh.
ma'am.
That one Pradeep Singh has already been granted bail, and so also the other person, one Mr. Guneshwar Bharali, Guneshwar Guneshwar Bharali, Bharali, and one Guneshwar Bharali, who was also named in the FIR was also granted bail by this court on, do you remember the date?
On the
No
10th
idea.
of the month.
The other
10th, the 10th of the month.
10th,
10th of the month. Yes,
10th of July.
that is correct, Your Ladyship.
On 10th July by this court in anticipatory bail petition. The other case number. You were just
1565 of 2025.
1565 of 2025. And accordingly, she has prayed that the interim order passed on 26/6/2025 may be made absolute. Stop. This court has considered the prayer of the petitioner and also the facts and circumstances of the present case. Stop. It is also seen that the petitioner has been cooperating with the investigating agency and has appeared on 29/7/2025. Stop. Therefore, the interim order dated 26/6/2025 is made absolute. Stop. However, the petitioner shall continue to cooperate with the investigation and shall appear as and when summoned by the IO without fail and provide all the documents which he was directed to produce without fail before the investigating agency. So, with these terms and conditions, the petition is disposed and the interim bail is made absolute.
Would you oblige?
Yes.
Leadership.
Much obliged.
For orders, item number 5.
Lordship,
May I please, my lady? My lady, in this case, I believe service upon respondent number 5 and 6 are yet to be completed, my lord. And can you be hearing on behalf of
I filed my written objection on behalf of 1, 2, 3, and 4. But due to the absence of the learned counsel for the appellant, copy could not
You
be
could not
served.
serve.
But today I've made an arrangement to send it through one of Dimapur-based lawyer. So
yes,
my friend will receive it during the course of the day. So may I pray that Lordship, if it is agreeable to my learned friend, a short hearing may be necessary for the condonation. So fix it
Delay
next-
is also there.
Yes, Lordship. So if the matter could be fixed on next week, if my learned friend agrees, on the 7th.
7th,
my lady, let me just have a look on the calendar. Okay, 7.
Learned counsel for the parties are present. Stop. Learned counsel, Mr. Apok Pongoner, appearing for respondent number 1, 2, and 3.
My lady, can it be on 8th, my lady? 8th on Friday.
It may not be possible
Yes,
because
it will be a last day for.
8th, last day, and then plus everybody is going to Itanagar
Okay.
on 8th.
Okay. Okay.
7 is a good day.
7th is.
Okay.
Learned counsel for the respondents number 1, 2, and 3, Mr. Apok Pongoner, submits that the objection on behalf of respondent 1, 2, and 3 has been filed in the present case, and a copy of the same shall be served on the petitioner during the course of the day.
Yes.
During
I've sent it to the learned counsel, Mr. Wapang.
we'll just say during
Yes.
the course of the day. Stop. And accordingly, praise for listing the matter on 7th August. Stop. Accordingly, list the matter on 7th August for hearing on IA,
Yes.
IA 68 of
On the
2025.
condonation.
Yes. Then regarding notice, para, the notice on respondent number, the return service of notice on respondent number 4 and 5 is still awaited. 4 and 5, isn't it, Mr.
No,
Devnath?
No,
five, 5 and 6.
Oh,
even.
5 and 6.
I am representing 1 to 4.
Okay, 5 and 6 is still awaited. When did you take the steps? 5 and 6?
My lady, 1,
25, 4, 6, 25. Okay. List on 7th.
Oblige.
Yeah. Little more time. Okay, then we see the 2 item. That's better, no? Any other items left? That's all. Then after it comes, you can inform. When the file comes,
Item number 4 for disposal now. Interview all over, interview all over, anything. Interview, pen drive. Interview all over, interview all over.
20 people have taken out your pen drive also.
Report number 3, report number 2. I mean, there it is. forget to charge at home. No?
Council's waiting for a court. Court has to wait for that.
This being the advantage is that she was former official of the Procedural. Having been the Gauhati and all these people, that is big problem. Okay, it's my time to finish up my work then.
I'm sorry for the
Unlisted
inconveniences
motion.
Lordship caused to you.
Unlisted motion, item number 14.
I'm very sorry, Lordship, for making Lordship to wait, Lordship.
Yeah, it's okay.
It is the council, so should wait for the court, but the court
No,
had to
maybe,
wait.
maybe they had left the court.
My
already,
learned
huh?
friend, Mr. Mua, was on Dix in court number 1.
Oh,
That's how there was some delay, Lordship. Lordship, before coming to the petition, in summary, in a gist of the summary of the case is, Lordship, this matter relates to selection in the MBBS seats for the state of Nagaland for the year 2025-26. And we are concerned with 42 seats of the central pool. Not altogether, there are 152 seats, MBBS seats. And for that, NEET UG was conducted.
Yes, yes.
And then on the basis of the marks secured in the NEET examination, 152 candidates have been shortlisted.
okay.
As for the selection is made on the basis of the examination in the NEET. Lordship is well aware.
Yes.
Earlier, the state of Nagaland was conducting the state selection. That provision was also there, but they have done away with that practice. And now it is on the basis of the merit. And the government of India has issued notification from time to time, the guidelines, how the merit is to be considered and in what manner. And there is a provisions for the central civil services employees, central government service employees, that persons, children of those employees should be treated at par with the local residents of that particular state. That instructions have been given by the center. However, if at all state wants to make their rules, then the concurrence of the central government should be taken in that regard. So that is the provision, the standing provision. It was issued on 9th of December 1986.
1986.
Yes, that is still continuing till today. The same notification, similar notification, and every year when the central poll is given, then with that a notification, a guideline will be given. each and every year it will be issued to the state government. State government has to follow that. So that is the practice till 2024. Now, Lordship is well aware, Nagaland did not have a medical college till 2023. From last year, we are getting 100 seats in the medical college, NIMSA, and out of that, 15 is general, and 85 seats are reserved for the indigenous inhabitants of Nagaland, but we are not concerned for all this. We are concerned here with regard to 42 seats of central poll, and Lordship is well aware that seats of the central government will collect the seats from different medical colleges all over the country, and then the seats are being allocated on the basis of the scoring of the NEET, in the NEET exam. So, the petitioner's father is posted in the state of Nagaland as the commanding officer in the 1st Battalion NCC, National Cadet Corps.
Okay.
And she applied, appeared in the NEET, and she secured 455 marks. And the first person who stood in the first position, she got 486 marks. And second is the petitioner, she secured 455 marks. And the next, who is shown in the list as serial number 2, who scored lesser mark than the petitioner, is 451 marks she secured. So I come within 1 and 2, my marks, 455 marks.
The first one got
86.
86.
And the petitioner got 455.
And the third one got 451.
Correct, Lordship. So that is the scoring. Now, having not selected in the list, the department has prepared a provisional select list. So, in the list, the petitioner's name has been placed in category 3. Department has made 3 categories. One category, general candidates. I will come to the relevant portion. This is just a summary, Lordship. Second category is the backward tribes, as Lordship is well aware that there is a reservation. Third category is the central services employees, the children of those. And then along with that, the candidates who were rejected, a rejected list was also prepared in one category. Petitioner's case is also not among the rejected list because that shows that the petitioner is eligible to be considered. So there are few rejected candidates, she is also not there. But her name was not included in the provisional merit list for the counseling, which was fixed on 30th July 2025, that is today. But by a subsequent order, it has been deferred to 4th August. Now, having failed to figure in the list, the father of the petitioner submitted representation to 3 agencies, that is, to the director, to the Chief Minister of Nagaland, and to the ministry also. And as per the guideline of the central government, issued from time to time, it categorically says that when there is a complaint or grievance on this issue, then it has to be disposed of in a time-bound manner. That is also there. Till date, today is the date of counseling, had there been no extension. He could have been intimated, at least mail, address, everything was given. No intimation till date, even till now. There is no intimation at all from respondents. That's how petitioner was compelled to file a writ petition before this Honorable Court. And then this Honorable Court has directed the state respondents to consider.
Had approached earlier.
Yes, this is the second writ petition. Because in the first writ petition, what happened? The Council for the State has brought one notification of 9/9/2021, which says, framed by the state, which was contrary to the central government guidelines, which says that in order to avail the children of central service employees, then a person should have passed class 10 and 12 from the state of Nagaland, and further should have been posted for at least 3 years in the state of Nagaland. That is the criteria. Based on that, my candidature has been rejected.
That is the rule made by the state
Yes,
government.
without the concurrence of the state and in violation of the Government of India guidelines. That is why I'm compelled and constrained to challenge that notification in this present
also.
petition. Otherwise, in the earlier round of litigation, what happened, Lordship? A direction was given by this Honorable Court to allow her to attend in the counseling, provisionally attend in the counseling on the 30th, that is today, which has been deferred. That is one. And to reserve some seats in the NEMSA also, if possible. That was the direction. Thereafter, three important developments have taken place after the order has been passed by this Honorable Court on 28/7/2025. That is day before yesterday. What happened? During the course of hearing, I made a submission that, look, this notification has not been displayed in the portal of the department. That is 9/9/2021. Now, in the evening, that is 28 July, in the evening of 28 July, they have uploaded that notification to show that it is there in the website. That is in there. I will take your Lordship's attention to that. Number one. Number two, in view of non-receipt of some seats from the Government of India, the counseling has been deferred to 4th. So that is one aspect. And the third one is a revised list of the candidates was also up in the website of the department on 29th evening. That is after 1 day, after the court has passed the order. And immediately we have furnished the order of the court also to the authorities. What happened?
So in that revised list, was she there?
She is not there. That is how we are constrained and compelled to approach this Honorable Court, challenging the notification of 9/9/2021, because during the course of hearing of that earlier writ petition, the contention made by the state was, because of this notification, she was not considered. So, just quickly, Lordship, may I come to the relevant provision? Her marks are not disputed. The father's posting is also not disputed, so I will not trouble your Lordship in that, because the learners, in the earlier proceeding, the court has already observed. The notification is, Lordship, at page 28. I'm talking about these 42 seats concerning those central poll only. I'm not on the other seats. This is 9 December 1986.
Page 28.
Page 28, Annexure T. It is a short, I will read only paragraph 1, 2, and 3. As your Lordship correct? Yes. May I read, Lordship? As you are aware, we have been allotting MBBS, DBS seats to your states, union territory for the selection and nomination of eligible candidates. Some instances have, however, come to our notice. This is very important. Non-compliance of the Government of India's direction. Some instances have come to our notice where some of the allotee agencies have not followed the relevant instructions issued by the Government of India while selecting and nominating candidates against the seats allotted by us. That means central pool. Now we are having 42 seats. Number two, it is once again reiterated that only the children of permanent residents of the state, union, territory concerned, the employees of the state, union, territory government concerned, the employees of the central, other state, union, territory governments on deputation to the state, union, territory concerned, and the employees of the central, state, union, territory government posted in and having their headquarters within the state or union territory concerned will be eligible. This is about the eligibility criteria. Number three, this is again very important. The children of central, state, union territory government employees aforementioned should be treated at par with the local residents. We are on this, Lordship. Should be treated at par with the local residents. That means they should be treated equally. The sole criteria for selection will be the academic merit of the candidate. Now it is the need, Lordship. That is the only change.
Yes.
And then subject to any special orders, again this is very important, issued with the concurrence of the Government of India. So concurrence of the Government of India is a must. And this notification is consistently followed from time to time by the Government of India. And again, a similar notification. Of course, there are guidelines up to 2016-17. I'm not referring to this because all are same, the criteria. But the latest one, which was pertaining to the last year, the letter of the Ministry of Health and Family Welfare, page 58, Annexure F. If you, Lordship, get the annexure, then may I read?
Yes, initially.
The relevant portion only. This is addressed to the Secretary Medical, Health and Family Welfare Departments to 9 states, and Nagaland is shown on the top at serial number 5.
This is the latest.
That this is pertaining to last year. For this year, we are expecting this kind of a letter, but it will come only at the 11th hour when the counseling is to be held. Because after finalizing the seats, then only they will intimate. So for written reference, this is last year's thing. And the subject is Central Poll MBBS and BDS seats allocation for the year 2024-25 regarding. And then paragraph 2. Roman 1. It is once again reiterated. That means again and again the central government is reiterating that only the children of permanent resident of state, union territory concerned, the employees of the state, union territory government concerned, the employees of the central and other state, union territory government on deputation to the state, union territory concerned, the employees of the central and other state, union territory posted and having their headquarters within the state, union territory concerned will be eligible. Number 2, the children of central, state, union territory government employees aforementioned should be treated at par with the local residents. We are challenging the 9/9/2021 notification because of this. For not complying with this direction of the Government of India, who is the owner of the central poll seats. Along with the seats, they are giving instructions to the respective governments to adhere to that. And then kindly come to Roman 6. Any complaint, grievances with regard to the selection of candidates may be redressed in a time-bound manner. This is to show the urgency. And for this year, we are anticipating that this type of a letter will be received. And then kindly come to next page, page 59, paragraph 9. On the basis of this, the petitioner has the right to consider. It is requested that the state, union territory should nominate their candidates on the basis of merit system devised by them. Keeping in view the above guideline, the children of all India service officers posted in these states, union territories ought be eligible to participate in the said merit system. So it talks about merit only, nothing else. And with regard to the eligibility, petitioner, in view of this, the petitioner has a right to participate on merit. And they have not rejected my list as was mentioning earlier. So I'm eligible. And kindly see the merit list in the next page, that is page 60. And this is annexure A with the, it comes with a notification. Merit list of the candidates for Nagaland State NEET UG for the academic session 2025-26. Now kindly see serial number 1, the marks, merit NEET marks is shown, 486 serial number 1, and serial number 2, Otungbi Ochami Sumi, marks is 451. Petitioner, as I have mentioned, she secured 455, but she has been placed in a different category and not included in the list. I'm questioning why. When the Government of India directive is to treat the children of the central government employees at par with the local residents, number 1. Number 2, if at all any deviation is to be made by the state, That has to be done with the concurrence of the central government. That was not done, that was not obtained. Number 3, the sole criteria for selection is the merit, and the merit has been given a go by. Then, what is the meaning of mentioning merit even in the order itself, when it is not to be honored? That is my grievance, Lordship. Can we come to page 107? I have shown the marks, serial number 1 and 2, and the marks of the petitioner. 107, this is to show that how the state has arranged. This is Annexure B, list of category 3 and rejected candidates for Nagaland State NEET UG. And down below, Lordship will find in the middle of the page, rejected list. Lordship will find in the rejected list as many as 6 persons have been shown, and she is not there. Rather, petitioner's name figures at serial number 1 with the 455 marks.
Category 3.
Yes. When you are making 3 categories, you are making this category to make selection. Category 1, general, you make selection on the basis of the marks. Category 2, backward classes, you make selection on the basis of the NEET marks. How the reservation is to be regulated, the backward reservation, then that is different. I'm not there. Category 3, that is the candidates from children of the central government employees, and no selection from category 3. Then, for what purpose category 3 has been arranged? Just for the sake of decoration, or just because they are doing something, they have to do something? NEET marks have been totally ignored. I fulfill all the eligibility criteria, and petitioner is not among the rejected list. Therefore, what disqualifies the petitioner to be selected on the basis of the guidelines, criteria laid down by the Government of India for the central poll seats, and on the basis of the NEET mark scoring? If I'm disqualified in any way, yes, that is understandable. But then this is just to eliminate the others, which is contrary to all canons of law. And Lordship may kindly come to page 109. I will not refer to the representations because whatever I have submitted, all those points are reflected in the representation. It was for a moment, Lordship, yes. Page 108, sorry. So this is to show that under serial number 1, name of the post, MBBS post in the central poll is 42. We are on this.
42.
The petitioner's claim is on the basis for this, among these 42 seats, not in the other seats.
What is this not received? Remarks in the remarks column, not received.
Confirmation has not been received yet.
2, 3, 4 is received.
Otherwise, remark seats are 42, but before, at the time of counseling, after receiving the seats from the respective colleges, the counseling will be conducted. So, due to non-receipt of the, seats from all the institutions, that is why they have differed. And the representations, I am not referring.
Government Medical College, Assam, serial number 5 also not received.
Yes.
Then 13 also not received.
Now, let me skip the representations. Can you come to page 123, Annexure M? This is the notification issued by the Director of the Technical Education, fixing the date for the counseling on 30th July 2025. And I will refer only to the relevant portion. This was issued on 24th July 2025, serial number 1 and 2. This is a provisional selection result and is subject to change depending on the availability of anticipated seats and options exercised by the candidates. Number 2, this will be relevant. Failure to attend the state counseling shall be assumed as declined, and their candidature and for selection and nomination to MBBS and allied course and BBS and AH shall be forfeited. So if I fail to attend the counseling, then automatically it will be forfeited. This was to be held on 30th July 2025, but subsequently they have postponed it to 4th August 2025, which Lordship will find at the in the next page, page 124. This was issued on 29 July. Court order was on 28 July, and this order was passed after this Honorable Court passed the order. Let me read the first paragraph. Notification. Number so and so. In view of the delay in receiving the allocation of central pool. So this is the reason why there is no notification. Government of India seats MBBS course. The state counseling for NEET UG 2025 has been postponed to 4th August 2025, 10 a.m. And rest are not relevant for us. These are for other subjects. And now, can we come to the order passed by this Honorable Court on 28. Since it is only 5-page judgment, I may be allowed to read so that Lordship will also be aware about developments. Page 126. Has the Lordship got it? Yes. Let me read from paragraph 2. The petitioner, Ms. Batsala Banghal, is aggrieved by the select list dated 24/7/2025, more particularly Annexure L of the petition, as in spite of scoring more marks than the second candidate in the merit list of the candidates for Nagaland State NEET UG for the academic session 2025-26, the petitioner's name did not appear in the merit list. 3. Annexure P of the petition is the list subcategory 3 and rejected candidates for Nagaland State NEET UG 2025, and the petitioner's name appears at serial number 1, and her marks are clearly shown as 455 with the state rank so-and-so. The petitioner's name does not appear in the rejected list, and petitioner is therefore aggrieved as she has scored marks above the candidate Mr. Hotun A. Ochami, who has scored 451 in the NEET qualification examination. This impelled the petitioner's father, Mr. Lovilesh Pangal, to submit a representation to the Ministry of Health and Family Welfare, but there was no response from the ministry. The petitioner's father then submitted 3 representations on 19/7/2025, annexure so-and-so, to the Ministry of Health and Family Welfare, to the Chief Minister of Nagaland, and to the Director of Technical Education under the Government of Nagaland, respectively, clearly explaining the petitioner's plight and the injustice meted out to the petitioner while preparing the merit list of the candidates for the Nagaland State NEET UG for the academic session 2025 to 2026. It is submitted that the petitioner's cutoff in the PCP group was 89.33%, and she has scored 93% while clearing her 10+2 under the CBSE board. The petitioner is thus dissolution as she was arbitrarily dropped from the aforementioned merit list. Annexure A is the petitioner's marks and mark sheet reflecting the cleared her class 12 board exams with flying colors. Annexure P is the NEET score of the petitioner, clearly reflecting that she has scored 455 out of the total of 725. It is submitted on behalf of the petitioner that since 9/12/1986, the strategy of the central government was to provide admission to children of 1. Employees of the central, other states, union territory government, anti-petition to the state, UT concerned, and the employees of the central, other state, union territory government hosted in and having the headquarters within the state, union territory concerned. The children will be eligible for admission on being allocated seats in the MBBS and BDS stream. 5.1. Annexure D is the letter to the so-and-so, which clearly reflects the quota to be allocated and reserved for the candidates under different categories, including employees of state, union territory, and central government. It is also clear that the children of the employees should be treated at par with the local residents, and the criteria for selection will be academic merit of the candidates, subject to any special orders issued with the concurrence of the Government of India. Now it is changed to NEET. it is submitted that the present petitioner is meritorious student. Her NEET score is second in order to the candidate at cell number 1 of merit list annexure G6. The strategy of the central government to provide allocated seats on the basis of reservation in different categories has been continuously followed since 9/12/1986, and annexure F is the letter dated so-and-so of the Ministry of Health and Family Welfare to the Secretary, Medical Health and Family Welfare Department, Government of Nagaland, and other union territories and state governments, which clearly reflects that the petitioner is a deserving candidate as her father is posted as Headquarter Colonel at NCC GP Headquarter, Kohima, under the Indian Army, and annexure C is the WP message to the petitioner's father, which proves her father's posting in the state of Nagaland. The wireless message is dated 6/6/2024. It is submitted that 85 seats in Nagaland. This is something distortion to what was submitted, but this is not very vital, but this is since part of the judgment I'm reading. But we are concerned with the central poll of 42 seats only. Yes. It is submitted that 85 seats in Nagaland Institute of Medical Science and Research, Nagaland, are allocated from the central poll to pursue MBBS and BDS in the state of Nagaland, and the petitioner was a deserving candidate as her father was working under the Indian Army. The petitioner is distraught as her name has not been shown in the reject list, whereas she is clueless as to why her name has been shown as list of category 3 without being selected in the merit despite scoring second highest in the NEET scoring. Here little illustration will be required, Lordship. Here during the submission it was submitted that, look, even in the rejected list my name is also not figured, therefore I am among the candidates who should be considered. But why my name has not been figured in the select list? By placing in the category 3 doesn't mean that we should not be considered. They have placed us in category 3. From there also...
So actually category 1, 2, 3 should have been called.
Yes, all should be treated equally.
Except the reject list.
Correct, yes, Lordship. So little distortion is here, but then that is not pertinent also. Paragraph 8. The NIMSAR was established in the year 1923, and this may be fallacy on the part of the respondents which led to this arbitrary decision. 9. Mr. C.D. Jamir, Learned General Counsel for the petitioner, has submitted that the petitioner has approached this court owing to the paucity of time, and at this relevant hour, the petitioner's case cannot be decided on the merits projected by the petitioner. The petitioner may be allowed to appear for the counseling, and thereafter her selection may be considered according to the notification submitted by the Learned Senior Government Advocate, Mr. Moa Amjen. The Learned Senior Government Advocate for the state respondent, Mr. Moa Amjen, has represented and accepted notice on behalf of the respondent number 1, 2, 3, and 4. The state of Nagaland parties' names are shown. Paragraph 10. The Learned Senior Government Advocate, Mr. Moa Amjen, has submitted that the category 3 of the MBBS list, annexure B, has been clearly described in the notification number so-and-so, dated 9 September 2021. This is the MBBS order in the present petition, Lordship. The petitioner was not selected as she could not fulfill the criteria of eligibility under category 3, which mandates as below. A. The candidate belonging to the non-local indigenous inhabitants of Nagaland as per PNR Department notification so-and-so 28 April 1977. We are not very much concerned with that. Children of non-local, we are concerned with this, Lordship. Children of non-local state government employees and children of All India service officers born on Nagaland cadre to be eligible under category 3B. The candidate should have appeared past class 10, 12 or equivalent from any of the schools within Nagaland, and his or her parents should have been residing and posted in Nagaland for at least 3 years or more. Both the criteria should be fulfilled. This is the MBBS order we are challenging here in this petition. Paragraph 11. It is not disputed that the petitioner did not appear class 12 board examination from any of the schools within Nagaland, nor her parents were residing in the state of Nagaland for the last 3 years or more. The petitioner has not clearly mentioned the duration, tenure of her father's posting in the state of Nagaland. In the document, it is 24 months. Now, 12. In reply, the learned counsel for the petitioner has submitted that the petitioner was not at all aware about the eligibility criteria as per notification dated 9/9/2021. It is further submitted that the criteria of presence of her parents in the state of Nagaland for 3 years, as well as the mandate to appear class 12 board examination from the state of Nagaland, is in violation of the letter dated 9/12/1986. This is the Government of India letter, Lordship. As it is clear from the letter that the children of Central, State, and Union Territory employees should be treated at par with local residents, and the criteria adopted by the state and the orders issued by the state has to be in concurrence with the Government of India. The notification dated 9/9/2021 does not highlight or reflect if the same was issued in concurrence with the central government. Here, Lordship, I was referring about 9/9/2021. It is not uploaded in the website of the department. They have, that evening itself, they have uploaded in the website on 28/7/2025 evening. Paragraph 13. The learned counsel has submitted that today, when the notification has been submitted on behalf of the respondents, the learned counsel for the petitioner has learned about the criteria which was not uploaded, and thus, even to challenge the illegal notification, which was without the concurrence of the central government, the petitioner is short of time as the counseling is still to be held on 30/7/2025. 14. I have considered the submissions at a par with the circumspection. It is true that the petitioner has scored 455 as NEET marks, and the merit list clearly reflects that the candidate with serial number 1 has scored higher than the petitioner, whereas serial number 2, the NEET score of the other candidates are much below the petitioner's score. The petitioner's father is also posted at Kohima and is a central government employee. 15. It is submitted on behalf of the respondent number 1 to 4 that notification dated 9/9/21 reflecting the eligibility criteria of the candidate category 3 candidates has been notified through gazette notification, and as claimed by the petitioner, this cannot be the path to bend rules to accommodate the petitioner's candidature in a haphazard manner. 16. The respondents have clearly explained why the petitioner was not selected in the merit list and her name appears in the list of category 3 and rejected candidates for the Nagaland State NEET UG 2025. There is no dispute that the petitioner cleared her class 12 board examination from the convent of Bagan Party Mohan Garden, New Delhi, with flying colors indeed. 17. At this juncture, this court is not inclined to allow the petition and quash and set aside and revise the ambient list dated 24/7/2025. However, the respondent authorities are directed to allow the petitioner to participate in the counseling scheduled to be held on 30/7/2025. Here, Lordship, I have challenged to quash the entire list, but court said that no, we are not quashing, but let the petitioner be allowed to attend in the counseling. 18. The notification is dated 9/9/2021, and it is amply clear that this is a recent notification. It is not disputed that the medical college was recently established in the state of Nagaland. Less circulation of the notification or non-inclusion of the notification in the advertisement violates the right to equality. The rule introduced on 9/9/2021 and not communicated properly cannot be introduced to defeat legitimate expectations, particularly when there is no willful concealment or misrepresentation by the candidates. The candidate's education and domicile of her parents has not been concealed, and the petitioner, who was the highest NEET scorer in the state's merit poll, is being excluded solely owing to a newly introduced and poorly published rule notification. Apart from the gazette notification, admissibly, there was no publication of the notification. 19. It does not appear that the petitioner is trying to pin rules, as the petitioner had approached this court when her father's representation did not invoke any response from the authorities. Already, the quota has been carved out by the government, union, and states, and this does not include domicile-based preferences, but to students of parents working under central government, state government, and union territories. 20. Thereby, the respondent authorities are directed to allow the petitioner to participate professionally in the counseling scheduled to be held on 30/7/2025. the authority may explore possibilities if one seat can be kept vacant without holding the process for others pending disposal of this writ petition. This Honorable Court was very conscious about the welfare of others, but then we are not concerned with the other vacancies except the central poll, which is of 42 seats, Lordship. 21. The respondents, particularly the respondent number 2, 3, and 4, are at liberty to take any decision relating to petitioner's eligibility for admission to pursue her MBBS course at NEMSA for the academic session 2025-2026 in accordance with law. Meanwhile, furnish extra copy to the respondent during the course of the list and matter after 4 weeks. So, as I have been mentioning before, 3 important developments have taken place after this judgment. That is, they have uploaded the notification of 9/9/2021 only after this Honorable Court passed the order. That is, next page, page 132. And here, Department Circular's notification, title, date of issue, view, download is shown in a column. Now, after the judgment is passed, 3 important development is, one is they have uploaded the notification of 9/9/2021 in the evening of 28/7.
Yes.
Second development is they have rescheduled the date for the examination, that is rescheduled on 4th. And another very, just for a moment, Lordship, may kindly come to page 133.
Yes.
The column Lordship has seen in the page 132, the title, date of issue, view, point like that. The top one, revised professional select list NEET UG 2025. That is, in the second column, Lordship will find 29/7/2025. That is 1 day after this Honorable Court passed the order. And in that list, I will refer to the list, she is not included. And second is, in the same page, 133, guidelines for selection to state reserved seats under various central seat allotment.
Now, this is the impugned notification.
Yes, 9/9/2021. It was on 28/7/2025 in the evening itself. Now, kindly come to the list, 137. This was uploaded in the department website after the order was passed by this Honorable Court on 28/7/2025, and this revised list was prepared, professional revised list was prepared only on 29/7/2025 after this Honorable Court passed the order. And this list is as same as the one which has been prepared earlier, which was under challenge in the earlier writ petition.
Here also category 1, 2, 3 is given.
No, here category is not given. For what reason they have not given, I don't know.
No, but this court by this previous order has already directed the state respondents to allow you to appear for the counselling. So that is protected.
No. They will still come to the judgment.
See, because it says 20, para 20, the respondent authorities are directed to allow the petitioner to participate provisionally in the counselling. So if they don't allow you to participate, then it amounts to contempt of this order.
Lordship, they may allow me to sit for the counselling. They will offer me a cup of tea. Yes, you have come. Yes. As per this criteria, you are not eligible, so we will not consider your case. So a direction should be given to the respondents. Do consider my case in terms of the guidelines issued by the Government of India. For the 42 seats, I am not trying to snatch away anybody's right, but the rights which I deserve in terms of the Government of India's direction, I should be treated at par with the local residents, and the sole criteria for selection should be on the basis of merit. What disqualifies me? and disqualification is only the notification of 9/9/2021, which was made by the state contrary to the guidelines issued by the Government of India. The owner of the seats, who is allocating the seats, have given specific and categorical instructions to all the states to strictly adhere to the notification while allotting the seats. That was arbitrarily taken away. So long as this notification remains, my case cannot be considered. They may allow me to come and participate in the counseling, but no, as per this criteria, you are not qualified. This criteria itself is illegal. That is what I am challenging, Lordship. On the ground. And Lordship, kindly come to the immune order. I am confining only to the MBBS, that to central poll, confining to 42 seats only. And this notification is a general notification for all the seats, for various central seats allotment for undergoing undergraduate course in engineering and allied, medical and allied, and agri and allied. I am not trying to disturb any one of this. I am concerned only to MBBS, that too confining to central pool. And I am claiming on the basis of the guidelines issued in this regard. Therefore, the arbitrary notification of 9/9/2021 has to be stayed and suspended to the extent of MBBS, and they should consider my case in accordance with the guidelines laid down by the Government of India. And I'm not questioning on the reservation also. State has got 152 seats. Out of 152, 42 is the central poll. And I'm contending my rights only on that, basing on the guidelines issued by the Government of India, who is the owner of allotting the seats. Yes, no doubt, it has been allotted to the states, but strict guidelines has been given to strictly follow the guidelines of the central government. And my question is, if at all you want to frame your own role, have you taken the concurrence of the central government? Kindly see the notification. Copy 2 has been sent to as many as 11 categories. None of the copies have been sent to the Government of India. And it is, I'm certain that no concurrence of the Government of India has been taken. And if at all state wants to deviate and frame their role, the concurrence should be taken from the central government. That has not been taken. And on top of that, the NEET score has been ignored. And the Government of India notification clearly says that selection criteria should be purely based on the scoring obtained in the NEET examination. If that is to be ignored, what is the point of maintaining the merit? Merit has been given a go-by.
Who's appearing for the state? Yes. As per the direction of this court, the state respondents were directed to allow the petitioner to appear in the counseling. But why in the revised list issued on 29th, after the order of this court, why the petitioner's name was not included?
Even on 29th,
in the
the
revised list.
What is counseling, my learned senior friend has already explained, meaning of counseling. So, counseling does not mean that because the main select list, which was challenged in the previous writ petition, 134, was not set aside in quash by this honorable court.
No, that was not set aside.
That was not that was not set aside in quash.
And as categories.
And as such, the name of the petitioner in the present writ petition cannot be included because it was not touched by this court.
No, in that the petitioner's name was there in the category 3. In category 3, there were 3 categories.
Yes.
So petitioner's name was there in category 3. 1 was the normal candidates, 2 was the backward, and third category was the petitioners. So none of them from the category 3 are figured,
Yes.
isn't it?
Because category 3, Your Lordship, what is category 3? My learned senior
They are
friend
the
has
children
explained.
of those central government employees posted here.
That is,
Yes.
So this category 3, there are six applicants in the category 3. All of them were not considered.
So
in
that-
view of the,
That means none of them fulfilled that category, that criteria.
in view of the notification 9/9/2021
9 September.
issued by the authority of the state. Lordship, you will find the
See, when the court has directed you to include her in the counseling without coming for a review or for modification, how can you just leave out the petitioner's name?
No, we
You
will
cannot-
definitely, as per the direction of
cannot
this
do
court,
that.
we will definitely invite the petitioner for the counseling. Why not? This is the direction of the, we have highest
That's
respect
why-
for this court.
That's why. No, but when the name is not figuring, then how do you call
Yes.
for the counseling?
That
No,
is the
we'll
point.
call, we'll call. As per the direction, we will follow the direction of this court, we will call her.
Their sole determination is to eliminate
No,
others.
we will definitely call her. We have the highest
Anyway,
respect of the
you
majesty
will
of this
issue
court.
notice and then the interim, you have to call and let her appear on 4th.
Counseling, she was directed, petitioner was directed to call to the counseling. We will call.
And
We will call, we will definitely call.
candidates from category 3 should be considered for allocation of the seats. Calling is one thing, but what is the purpose of calling? Whether you can accept it or not. So I should be allotted with the seat if I deserve, if I qualify. And my contention is that as per the standing notification of the Government of India, who is the owner of all the allotment of seats, I'm eligible and deserve to be considered on the basis of the merit. And I should be treated at par with the local residents. That's all. And they have not treated in that manner. That is how I have been discriminated. Lord, the land has to be maintained, Lordship.
Okay. This is the second writ petition filed by the petitioner in connection with the counseling process for allocation of MBBS seats by the government of Nagaland. Stop. In the first writ petition, i.e. WPC 134 of 2025, by an order dated 28/7/2025, comma, this court had directed the respondent authorities to allow the petitioner to participate provisionally in the counseling scheduled to be held on 30/7/25. After this only it was extended to 4th.
Your Ladyship,
30s, yes.
excuse me for your
Yes,
district.
yeah, it's
But
okay.
allow me to see one word regarding the
Yes, yes, sure.
competency of the state to formulate this notification. That is 9/9/2021. Your Ladyship, may I take you to the Constitution of India? Article 246, 7 schedule. Article 246, 7 schedule. 7 schedule, it is shown three lists: union list,
Yes, yes.
state list, congruent list.
Yes.
May I take you to the congruent list? Congruent list is a list where both the union and the state can legislate. Congruent list, Lordship, may I kindly see congruent list? There is 3 congruent lists. In congruent list, number 25, education, including technical education, medical education, and universities, subject to provisions entries, subject to the provision of interest 63, 64, 65, 66 of the last one. I have read it, it is not relevant in our present case in hand. Education, including technical education, medical education. So now, both the union in the state are competent to legislate. And therefore, in framing our own notification, we don't need the requirement of a permission from the Union Medical Ministry. And this has been framed. Your ladyship, please appreciate. It is framed in 2021. And we are sticking to that. This is not framed in order to deprive the petitioner. We have not framed this policy in order to deprive the petitioner.
We will have to examine this policy
Lordship,
in view of this Government of India letter.
that is one, Lordship. Another aspect, considering the submission of my learned friend, kindly come to page 142, because I have not referred to your Lordship in this area. But since considering the submission made by the learned counsel, middle of the page, reservation, paragraph 2, page 142, that is the ambient order.
Reservation, yes.
I will just come to the point on reservation and A. Backward tribe reservation, 15%. A. Just the starting part,
Yes.
just quickly. And B. Persons with disability reservation, 5%. 5 plus 15 plus 5, 20.
20.
Now come to C. The remaining seats shall be filled up amongst the candidates belonging to the indigenous scheduled tribes of Nagaland, scoring minimum qualifying marks so and so, so and so. Reservation has not left any scope for consideration of all India service, even if found eligible as per notification 9/9/2021. Entire quota will be exhausted. 20% plus remaining seats,
remaining
all indigenous. See the selection criteria again. I may be allowed to read this. Criteria 143. Selection of candidates to various state reserved undergraduate technical and professional courses shall be through entrance examination conducted by the state, central government, other agency as notified by the state government. B. Only those candidates who secured the required minimum qualifying marks in the entrance examination shall be considered for selection. C. Selection shall be made based in order of merit of candidates in the entrance examination result, preference option exercised by the candidates and availability of seats. Separate merit list shall be maintained for all categories. And then E. If the seats are available, that means after exhausting all the remedy, who will refuse? If the seats are available, after selecting all eligible and qualified candidates belonging to the recognized indigenous scheduled tribes of Nagaland, then selection of candidates under category 3 will be considered. After exhausting all the remedies, what seats will be left for to be considered for category 3? This is what I am questioning, Lordship. Category preference will be given in the following. So it is very clear. After exhausting all the seats, how they can be a seats? The government has not applied the guidelines at par with the local residents. That has been ignored. This is nothing but to eliminate the central service employees, children of central service employees. And they have not taken the concurrence of the Government of India, as has been mentioned in the notification. So therefore, they have violated all the guidelines.
Since 21, they have been following this notification, but since 2021.
Yes, there may be candidate, there may not be candidate. If in the earlier occasion, nobody has raised and claimed their rights, that cannot be a ground for me not to raise any ground that since 2001, they are implementing and nobody has come, then they have not followed. So illegality cannot be perpetuated. Lordship is well aware on that point. If somebody was ignorant about the law, that do not compel me to remain ignorant.
Just come to that annexure F again.
Page,
Annexure F, page 58.
page 48.
The letter
Fif-
communication
yes,
on which
yes,
you are relying.
Yes, Lordship.
So here, the following points.
58.
Only the children of permanent residents of state concerned.
Here I would contain an paragraph 2, small Roman 2 and paragraph 9. This has been violated by the state. This has not been followed. And on top of that, merit criteria has been ignored. Guideline talks about the merit, where the merit will go.
Where does it say that the central government has to be consulted? You were showing the
Concurrence,
concurrence.
yes.
You were showing one particular. Where was that?
That is in the page 28, Lordship, paragraph 3. Paragraph 3, last 2 lines. Subject to any special orders. The sole criteria for selection will be the academic merit of the candidates. Now that is the merit marks. Subject to any special orders. The state government has issued a special order issued with the concurrence of the Government of India. And this notification is consistently followed till 2024, till last year. And I have not referred to a guideline of 2016, which is available at page 52. There also eligibility conditions are reflected. This is more illustrative also. Here also Lordship will find what is the guideline issued by the Government of India. Elaborately, they have given from page 52. Guidelines for selection and nomination of candidates against Central Poll MBBS PTS seats for the academic year 2016-17, and that has still been followed till date, where it says about the children of the central government employees should be treated at par with the local residents. That is very clear.
And 11 states are identified
Yes.
for this beneficiary states. Nagaland is also one of them. Okay, we'll have to examine this notification. Okay, what did I say? Yeah.
Your Ladyship, please
Yes.
appreciate this also. This is the
What is that? Let me see.
No, for
28
now, we will only issue notice and then,
28 July.
what is this?
This is written on 28 July, that is day before yesterday. And this is that relates to the representation which has been submitted by the father of the petitioner to the authority. So from 28 July we are processing. May I read your Ladyship for your
Yes, yes.
Government of Nagaland, Directorate of Technical Education, Nagaland, Kohima. To the Secretary to the Government of Nagaland, Higher and Technical Education Department, Kohima, Nagaland. Subject: clarification on the letter received from Colonel Lovelace Pankal, citing discrimination of wards of government officers performing duties for Nagaland State in regard to the medical and allied colleges course, NEET UG. Madam, in inviting reference to the subject cited above, the undersigned would like to submit a clarification on the letter received from Colonel Lovelace Pankal, citing discrimination of wards of the government officers performing duties for Nagaland State in regard to medical and allied seats under the Central Board Reservation quota for your kind information. That Colonel Lovelace Pankal, Commanding Officer 1, Nagaland Battalion, NCC, Kohima, based on the Ministry of Health and Family Welfare, Government of Nagaland, Nirman Baban, New Delhi, so and so, dated 9 December 1986, and number so-and-so, dated 20 August 2016, which specifies the beneficiary states of Central Board, MBBS, PTs to accommodate children of Central State UT government employees for selection to this Central Board seats as at bar with the local indigenous residents of the state, copy enclosed, claiming one MBBS seat for her daughter, post NEET UG 2025 merit agent number 2. Further, it may be mentioned that the latest ministry guidelines for allocation of MBBS PT seats number so-and-so, Ministry of Health and Family Welfare, Nirman Bhavan, New Delhi, dated 12 August 2024, section 1.5, under reservation, which states that the reservation policy being followed by the concerned beneficiary state union territory will apply on Central Board PTs, MBBS PT seats. The existing Nagaland State Reservation Policy, byte number so-and-so, dated 9 September 2021, stated that the children of non-local state government employees and children of all India service officers born of Nagaland cadre are placed at category number 3B and to eligible under category 3. The candidate should have appeared bus class 10, 11 or equivalent from any of the schools within Nagaland. In her parents should have been residing and posted in the Nagaland for at least 3 years or more. Both the criteria should be fulfilled. Copy enclosed. Whereas Colonel Lavish Bankal case, he was posted in Nagaland on 6 June 2024 and has not completed 3 years of service in Nagaland. And also, his daughter, Ms. Vatsala Pankal, has not done her schooling in Nagaland, which altogether does not fulfill the criteria. Copy enclosed. Therefore, in the line of the existing reservation policy, the candidate does not qualify for the candidature under category number 3B for study and medical and allied courses, and the caution of discrimination and injustice meted towards the government officer performing duties for Nagaland does not arise. This is for your kind information and necessary action. Director, School Technical Education.
Mr. Siti, this 12 August 24 guidelines, that is going against you.
How?
See, reservation, which states that the reservation policy being followed by the concerned beneficiary state will apply on central pool. So even in the central pool, the reservation policy being followed by the concerned state will be followed.
They have not wiped out the children of Central State Union Territory employees should be treated at par with the local residents. 12 August notification has not done away with that. This is nothing but to make the officers confused. This is the letter of the director. Basing on this notification of 9/9/2021.
24 ministry guidelines.
Basing on 9/9/2021, the director has rejected by applying the.
They are basing on the ministry guidelines.
Yes. Then,
see,
if they are thinking on that,
August
the entire notification has to be given effect too, which have not distinguished and differentiate between the central government employees and the employees of the state response. Let them show.
Reservation followed by the state government, the reservation policy, which is being followed in all the recruitments in Nagaland.
Lordship, I have a copy of the notification.
This 12th August 24.
Yes. Lordship, just have a look. I have this. 12 August and the next page. This has not done away with the earlier notification, which I have referred to. 13 August is just one day after this.
12 August 24. The reservation policy.
Lordship will find the eligibility criteria in the next page. It has never done away with the treatment of the children of the central government employees should be treated at par with the local residents. He is trying to make confuse by bringing all these irrelevant issues. This was addressed to the state of Nagaland. And Roman 2 is very clear. The eligibility criteria are laid down there.
Section 1.5.
Lordship, can you maintain?
At point 1.5 in this, it says reservation policy being followed by the concerned beneficiary state will apply on the central pool. At 1.5 in this particular ministry guidelines. So reservation policy means ST backward, that reservation policy.
Reservation policy kindly come to the ambient order. Page 142.
Yes.
Paragraph 2, reservation eligibility and reservation.
Yes, this is the reservation, 15%, 5%, this one.
And C is remaining seats. That means all the seats. That is why I am challenging this. Supreme Court has, in various cases, has laid down the law about the reservation. Even 80% is too harsh, and this is 10%. Whereas the question of considering the case of the petitioner in terms of the guidelines, governing guidelines of the Government of India. My grievance is on that.
See, this reservation policy of 9th September 2021,
Yes.
this is the policy which has been allowed by the central government by this ministry guidelines saying that this reservation policy will apply even in the central pool. That is what they are saying. The reservation policy being followed by the concerned beneficiary state will apply on central pool MBBS BDS seats. So which means this reservation, this policy which is given in 1921.
By going this 100% reservation, Lord Chief may apply your mind. Is it not 100% reservation? 15 plus 5,
20 and then
20, remaining seats. So 10% reservation.
Yes, 100%.
That means, what is the point of inserting the criteria for the children of the central government
At
employees?
this stage, we can say that one seat in the central pool can be kept till the final outcome of this case. That's the best that we can
interim,
come up with.
in the interim, I have read
No, for counseling, it's okay. But we will just say if in case the state respondents are saying that they are going by this policy and she's not eligible, then we'll have to examine this whole petition.
If she is not eligible, then she should have been rejected.
Then we'll have to examine this whole. No, that's why rejected, and now in that revised list, she's not there anymore.
No.
In the revised
If my
list.
name is rejected, then it should be in the rejected list.
In this page 137 list, the revised provisional
Another
list,
angle, from another
she's
angle.
not there.
This Honorable Court passed the order on 28 July.
Yes.
After passing the court order passed by this Honorable Court on 29, they have revised the list, and whereby this Honorable Court has categorically said that he should be allowed to participate in the counseling, which is not there. My name is not there in the list. Just, can I go by assumption that Honorable Court has directed me to participate in the counseling? Authority has not taken into consideration of that order.
Your Ladyship, for that aspect of the matter, as I have explained, we have the highest respect for the majesty of this court. We will definitely invite the petitioner for the counseling, provisional
Inviting for
counseling.
counseling is one of
As per the
but
direction
I'm concerned
ordered
about
by
the
the court.
allotment of seats in terms of the guidelines issued by the government of India.
We will definitely invite her.
And I should be treated at par with the local residents. The sole criteria is the merit. Therefore, and the notification is under challenge. There can be no 100% reservation. If that is the case, what is the point of inserting that condition in the Government of India notification?
Oh, okay.
It makes no point, no sense.
What did I say? To allow the petitioner. 37 to 2025. Stop. In the meantime, the set date has been postponed. The set counseling date has been postponed to 4/8/2025. Stop. This court had also directed the authorities to explore the possibilities if one seat can be kept vacant without halting the process for others pending disposal of the writ petition. Stop.
One seat is confining to central poll lodge.
One seat in the central pool, but it's not specified here, of course.
Yes.
It only says may explore possibilities if one seat can be kept vacant. Without, just continue with that, can be kept vacant without halting the process for others pending disposal of the writ petition. Stop.
For in term I have mentioned in page 22
No.
of the petition.
I'm just thinking. This impugn order of 9/9/21, it was produced by the state respondents.
Yes. On the day of hearing.
Yes. On 28/7/2025, when WPC 134/2025 was heard, the learned senior government advocate had produced a copy of the notification number HTE/RESERV/23-1/2012/474 dated 9th September 2021, wherein at paragraph 1, category 3B, paragraph 1, category 3B, it is stated that the children of non-local state government employees and children of all India service officers born on Nagaland cadre to be eligible under category 3B should have appeared / passed class 10/12 or equivalent from any of the schools within Nagaland, and his / her parents should have been residing and posted in Nagaland for at least 3 years or more. Stop. Both the criteria should be fulfilled. Stop. However, at the time of hearing, the counsel for the petitioner had submitted that this notification of 9 September 2021 had not been communicated to the petitioner, nor was it validly publicized by publishing in the website of the concerned department. Stop. Accordingly, the petitioner has filed the present writ petition challenging the legality of the notification dated 9/9/2021, specifically paragraph 1, 3B. Stop. The petitioner has also prayed for a direction to consider the case of the petitioner in terms of the directions dated.
Lord Chief,
Yes.
I am challenging the entire policy except that other allied services, like engineering courses and all that. But reservation policy I am challenging.
No, here you have
Paragraph
stated
2.
quash set aside paragraph 1, category 3 of the notification in your prayer.
The entire notification has been challenged.
You see your prayer portion. Quash and set aside paragraph 1, category 3B, 2C and 3E.
Category 3B and 2C.
And, yes. So to quash
And
and set
3E.
aside paragraph 1, category 3B, comma, 2C and 3E of the notification dated 9/9/2021. Of the impugned notification dated 9/9/2021. Stop. Petitioner also prays for a direction to consider the case of the petitioner. I think that I have already given. In terms of the directions dated 9/12/1986 and 9/12/1986. There are 3 notifications, directions, isn't it, by the central
Yes.
government? So, what were the?
Similar
Just
notification.
give all
The
the
other
dates.
is
Just
at
give all the dates.
page 58, 13 August 2024 notification.
And 13th August 2024, by which the Ministry of Health and Family Welfare, Government of India, had directed the state governments of Arunachal Pradesh, Tripura, Meghalaya, Ladakh, Nagaland, Sikkim, Lakshadweep, Andaman and Nicobar Islands, and Mizoram to treat the children of central/state/UT government employees at par with the local residents. Stop. And as far as the allocation of seats for MBBS and BDS seats in the central pool are concerned. Stop. Learned counsel for the petitioner, learned senior counsel for the petitioner, Mr. Siti Jamir, assisted by such and such,
I am challenging.
submits that in the said instructions/letters of the central government, it is specifically stated that the states/UTs should nominate their candidates on the basis of merit system devised by them, keeping in view the above guidelines. Stop. The children of all India service officers posted in these states/UTs would also be eligible to participate in the said merit system. Stop. Learned counsel further submits that in the instructions of the central government dated 9 September 1986, it is stated that the sole criteria for selection will be the academic merit of the candidates. as far as the children of central slash state slash UT government employees are concerned, subject to any special orders issued with the concurrence of the Government of India. So, the specific contention of the learned senior counsel is that the impugned notification dated 9th September 2021 is not has not been issued with the concurrence of the Government of India, and therefore the state could not have imposed an eligibility criteria as given in paragraph 1, category 3B of the impugned notification dated 9 September 2021.
Lordship, in addition, the impugned notification of 9/9/2021 is contrary to the governing guidelines issued by the Government of India.
And it is also submitted that the impugned notification dated 9 September 2021 is in violation of the guidelines issued by the Government of India through the Ministry of Health and Family Welfare.
Yes.
It is therefore the prayer of the petitioner to consider the case of the petitioner in terms of the directions dated 9/12/1986 and other consequent directions issued by the another subsequent directions issued by the Ministry of Health and Family Welfare, Government of India, in as far as the children of central government employees posted in Nagaland are concerned. Stop. Para. Learned senior government advocate Mr. Moa Imchen submits that the state of Nagaland has the power to issue necessary notifications and guidelines in view of the Schedule 7 of the Constitution of India, in which the state is serial number, you said 25, in which the state is empowered.
List 3, concurrent list.
Yes.
Serial 25.
In
List
the
3.
concurrent list at serial number 25, wherein the state government is empowered to issue guidelines under the education, technical education, medical education, and universities. Stop. He has also submitted that the latest ministry guidelines for allocation of MBBS/BDS seats dated 12th August 2024 has, under the heading reservation, stated that the reservation policy being followed by concerned beneficiary state/UT will apply on central pool MBBS/BDS seats. Stop. He has therefore submitted that this reservation policy has been reflected in the notification dated 9th September 2021 at paragraph 2, wherein the reservation has been given at 15% for backward tribe reservation, 5% for person with disabilities, and the remaining seats to be filled up from amongst the candidates belonging to the indigenous scheduled tribes of Nagaland, securing minimum qualifying marks in the entrance examination, including candidates belonging to the backward tribes, based on the merit and preference/option exercised by the candidates. Learned Government Advocate has therefore stated that in view of paragraph 1, category 3B of the notification dated 9 September 2021, the petitioner is not eligible to be selected for the MBBS seats under the central pool. Stop. In any view of the matter, this court has already directed the state respondents to allow the petitioner to undergo the counseling exercise. Stop. And the learned senior government advocate has also submitted that the petitioner will be allowed to appear for the same. Stop. Accordingly, it is further reiterated that the state respondents shall allow the petitioner to participate provisionally in the counseling to be held on 4th August 2025. Stop.
And consider for allotment of the seats in accordance with law. I have given in paragraph page 22 of my petition.
Anyway, issue notice returnable within 4 weeks. The state respondents are represented by the learned government advocate, and hence no formal notice is called for. Stop. Mr. Yangarwati, learned CGC, has accepted notice on behalf of the respondent number 5. Respondent number 5. Stop. In the interim, it is, where is the interim prayer?
Page 22, I have mentioned.
No, that prayer has already been given to allow you to. We'll just say no. Don't say in the interim. The entire counseling and selection process shall be subject to the outcome of this petition. I think that will do. So if she's selected, not selected, that also that we can consider later. And court has already said that one seat will be reserved, na? So that will
No,
also
Lordship,
be, yes,
that reservation consider
under
included-
the central pool. You
No.
want it to be reserved under the central pool?
Yes.
Yes. It is clarified herein that the one seat which was directed to be kept vacant will be from the central pool.
Lordship,
Yes.
even the Government of India notification says that in case of any complaint grievance, it has to be disposed of in a time-bound manner. So in view of that, Lordship, a short notice should be issued. And even accepting the fact.
2 weeks then.
Lordship.
Instead of 4 weeks, maybe 2 weeks.
One
We'll try to dispose of within 2 weeks.
very important aspect
Yes.
of the matter, Lordship. Even assuming I found eligible. You are not disqualified, I'm eligible. considering the notification of 9/9/2021, is there any scope to select from the category 3 when 100% reservation has already been made? That is contrary to the guidelines issued by the Government of India. That is why
No,
I'm
since
submitting
one seat
from
is
day
kept
one.
vacant, if at all you succeed, then you will be accommodated there.
Lordship.
Yes.
And
So-
that is why, Lordship, in the interim direction, my case should be considered in accordance with law for allotment of the seat. Otherwise, I may be invited to the counseling. Just have a cup of tea and go. You have come? Yes, go. What is the
Considered
point?
and if found eligible.
Lordship, when everything has been completed, selection, all this has been, this thing, how can, again, one should have to be accommodated. It is not sort of like a school admission.
No, but the order
The
to keep
procedure
vacant
that
is
we have
already
on the
there,
top.
already there in the earlier
Lordship,
writ
kindly
petition.
read para 20 of the order of this court.
See, the authorities may
The-
explore the
the-
possibilities if
the
one seat
respondent
can be
authorities-
kept vacant.
The respondent authorities are directed to allow the petitioner to participate provisionally in the counseling, scheduled to be held on 37, now it is 4/8/2025.
Yes.
Authorities may also explore possibilities if one seat can be kept vacant without holding the process for others pending disposal of this petition. Now we are exploring. Since we have been directed to explore the possibilities, we are exploring. But within our exploration,
Yes.
will
What will
benefit
happen?
the petitioner or not, that I cannot give assurance. But we are exploring.
Exploration,
We are exploring.
exploration should be strictly in accordance with the Government of India guidelines. State can frame any rules, let them file, but it has to be in consonance with the central guidelines because they are the owner of the seat.
No, we have to examine everything thoroughly. So we'll say 2 weeks. Moa, can you file your affidavit by then, within 2 weeks?
Within 1 week, you can file.
Yes.
Next week I will
When he
not
is
be
getting
there.
spontaneous instructions,
Yes,
Lordship,
yes.
there is no reason
You are
why he
getting all
can
the
take more
instructions.
time.
Next week, I am taking
That's
the
why 2 weeks.
Today's matter is moved unlisted and my learned friend is already having the
With all the
instructions.
instructions.
I appreciate that the prompt steps being taken by the State Council. So that way he can file the affidavit within a week's time.
And so far as time has been concerned, that is the
Regarding,
Regarding
regarding the urgency of the present petition, they let this matter after 2 weeks, before which date the learned senior government advocate shall file the affidavit.
Union
in
should also
opposition.
be directed to file the
And
affidavit
union
also.
also, yes, as well as the union government shall file the affidavit in opposition. Actually, the union government's reply is important in this case.
I don't know whether I'll get the instruction. I'll try my best, but.
Okay. Next.
It's okay, extra copy of the document.
Extra copy of the
Yes.
writ petition may be furnished to the learned counsels for the parties during the course of the day.